Have you ever bought a home only to find out that the sellers concealed a mold problem? Who's responsible? What if you're a business owner and your landlord is threatening to lock you out? Tonight we're helping you fight back on Toronto Speaks Legal Advice. Welcome to Toronto Speaks Legal Advice. I'm your host, Natalka Falcomer. Tonight we're guiding you through the murky waters of real estate law with Bob Aaron and Harvey Haber. Both Bob and Harvey are seasoned lawyers in real estate law. Bob Aaron is not only a legal columnist for the Toronto Star, but he's also served as a bencher of the Law Society of Upper Canada, the vice chair of the Law Society Foundation, and served as vice chair of the Lawyers Fund for Client Compensation. In 1993, he founded the Ontario Real Estate Lawyers Association. Among Bob's many other accomplishments, in 2014, he received the first President's Award of the Association of Ontario Land Surveyors. Harvey Haber, who's also here today, is a lawyer and also a certified mediator and arbitrator and QC. He is the recipient of the Award for Distinguished Services, the prestigious Osgoode Hall Law School Alumni Gold Key Award, and is listed in the Lexpert American Lawyer Guide to the leading 500 lawyers in Canada. Harvey is also the author and editor of numerous books, guides, and articles in both American and Canadian publications. Welcome, Bob and Harvey. Thank you for coming on. That was a mouthful and a half, stumbled over half of it, but I'm very excited to have both very seasoned people here to help cover both residential and commercial matters today, commercial real estate, both things that touch all aspects of our lives, whether we're just homeowners or also people that run businesses. And the first thing that I want to start off with, and you guys can fight over who starts, one story that really sticks out in your mind that teaches a really important legal principle about commercial real estate or residential real estate that people watching need to know.
Well, Bob, can I give it a shot? The most important key in regard to commercial leasing, at least in Canada, is the offer to lease. Mm-hmm. And what a tenant should do in an offer to lease is ask for the world, because it's the landlord who's dealing with the tenant at the particular initial stage. And the tenant should ask for an option to extend, an allowance. It should ask for everything it wants to, because the landlord can then respond to it. But if the tenant just signs a blank offer to lease, which says that the tenant will sign the landlord standard form of lease and offer to lease, then basically the tenant is out of luck, because what happens is a new team steps in, the landlord steps out, and inevitably the tenant hurts. What the tenant has to do basically is add one line to its offer to lease. And that one line is, which lease shall be subject to such amendments as are mutually agreed to by both landlord and tenant and their respective lawyers.
That's a wonderful piece of advice. In fact, something that I want to touch upon later on is an offer to lease really binding? When is it and when isn't it? That's something that is very important to our viewers at home. And of course, if you have a business, if you are a landlord yourself or you are a tenant, please call us. We're happy to help. It's 416-446-7090. Bob, it's your turn now. I know we have a lot to cover in the residential sector as well. Anything that really sticks out in your mind?
Well, the first piece of advice, actually three pieces of advice. Consult your lawyer.
Yes.
Consult your lawyer and consult your lawyer.
You're right.
First. Okay, that applies to Harvey's.
Absolutely.
Yeah.
Absolutely.
I think the most important thing that a lot of people do not do is get a survey when they're buying a house. Insist on a survey, because there have been a number of cases where there was just one recently, where somebody had to dig out their pool, which is on the neighbor's yard, and move it back to their own yard.
Oh, wow.
Tens of thousands of dollars.
And who would be responsible for that?
Well, if you buy a house and your pool, because you didn't get a survey, and the pool is on the neighbor's lot, a title insurance company may pay to fill it in, but not going to pay to move it. Mm-hmm. So get a survey, make sure that your house is on your land and your septic tank is on your land if it's a rural property. I've had situations where somebody was about to buy a house on the wrong side of the street because there was no survey. We stopped that deal until the titles were corrected. But always get a survey so you know where the house is, how big it is, whether your house is sitting on somebody else's land or somebody else's house is sitting on your land.
Would that same rule apply in the commercial situation? If you're a tenant and you need to rent a space out, should you demand a survey or some sort of...
What you should do
Yes.
is do a sub-search of the property, and Bob is right, get a lawyer, and get a, and in my books I indicate if you've got a commercial lease, get a lawyer who understands commercial